Excuse me, is it possible to make the room any cooler at all?
I've opened the windows up also to accommodation, so
Yeah, I mean, it's very hot and stuff.
email.
Okay, thank you so much. Well, you've heard that exchange. It's very hot, isn't it, in here? We'll carry on, but I've asked for efforts to be made to make the room as cool as it can be made. I think there's a storm about to break probably outside, so who knows, the air may get cleared in the course of the afternoon, I hope it does. But thank you. Yes, Mr. Brown.
Thank you. My Lord, you have my submissions now on the jurisdiction point. If the court's with me on that, that is enough to dispose of the appeal. However, if you find against me on that, in my submission, the appeal itself should still be dismissed on the basis of the second of the conclusions reached by Mr. Justice Waksman, that the respondent's intended use of the site is covered by Class Q. Obviously, if your lordships are against me on jurisdiction, it will be necessary to go on and consider that. I appreciate that if I succeed on jurisdiction, it might not be, and I note that the interveners have specifically asked the court not to go down that road. And well, that's ultimately, obviously, a matter for the court, but to the extent that the court seeks the respondent's views on it, I would respectfully ask you to determine the Class Q issue, whatever your conclusions on 296A. The first and most obvious point to be made in that regard is that you will have heard full argument on it. This will not be a minor aside. As much time would have been devoted to that issue as to the jurisdiction one. Second, in precisely the same way that Mr. Justice Waksman approached it, which is that the case might not end with him. Whoever wins and loses, the case may not rest here in the Court of Appeal, particularly given this is the first occasion the court's had to deal with these issues. The interveners argue that the evidence in front of Mr. Justice Waksman was incomplete, and indeed that may be part of the heart of the reason why they asked the court not to consider the issue. In my submission, however, my Lord, the key areas of dispute are not actually about the facts at all. They are about the approach to be taken to the interpretation of emergency. Questions such as, do you need to import wider concepts from dictionary definitions into the statute definition? Those are things that this court is entirely capable of grappling with. And indeed, the interveners themselves have had the opportunity to supplement my learned friend's submissions on that point. And that then takes me really to the last point, which is that, as the court is aware, there are already 3 separate applications for judicial review in which Class Q is being raised. We are aware from pre-action protocol letters of another possible 2 such applications concerning Bexhill. This is an issue which is going to keep coming up, and at some stage it's going to be important to have a very clear steer on it from not just from the High Court, but also from this court. And in my respectful submission, it would be entirely in accordance with a good practice and indeed helpful for everybody for this court to address the point, given, as I say, that it's been canvassed. But as I recognise that the court will take its own view about that. My Lord, can I then turn to the argument? It was and remains the Secretary of State's case that there's no basis for an injunction in this case because the proposed use of RAF Wethersfield is authorised by Class Q, and therefore there would have been no breach of planning control. And before Mr. Justice Waksman, it was common ground that as what had started out as an application for interim relief had, by the time it reached him, become an application for a final injunction, it was appropriate for the court to determine whether that issue was correct. If I can start with Class Q itself, you have that in the authorities bundle, tab 2, page 32. My learned friend's taken you through the provisions, but if I can just go back there and note some points as we go. First of all, the grant of the right itself, permitted development, page 32, Class Q, development by or on behalf of the Crown, on Crown land for the purposes of, and then the 3 categories: preventing an emergency, reducing, controlling or mitigating the effects of an emergency, or taking other action in connection with an emergency. Can I just pause there to make an observation about the three limbs, which is this, that if one looks at those three, in my submission, there is no temporal limit on when the emergency has to exist. And by that I mean that the wording is capable of embracing not only an existing emergency which subsists at the point the development right is relied upon, but also a possible future emergency and indeed also a past emergency. And I say that for this reason. First of all, if we look at limb A, preventing an emergency, that is plainly directed at a future event, an emergency that is anticipated but has not yet arisen. The second limb, reducing, controlling or mitigating the effects of an emergency, that could apply to an emergency which has yet to happen. It could apply to one which still exists today, but it could also, in my submission, apply to an emergency, the peak of which has passed, but which still has residual effects which require attention, whether that's mitigation or reducing the effects of. The effects of the emergency may go on beyond the emergency itself. And similarly, the third of the limbs, taking other action in connection with an emergency, in my submission, can also apply to a past, present or future emergency. And simply in terms of past, in the skeleton argument I give the example of an extreme weather event where there is an immediate need to address accommodation needs of people, which in the immediate short term is dealt with by a measure such as tents. But where once the immediate crisis has passed, the storm has gone, the flood has dissipated, whatever, there are still people living in tents and there is a need to take further action in connection with that same emergency. And I say if one looks at the simple wording of QC, there is absolutely no reason why, if in appropriate cases, action to provide something beyond mere tents could not be pursued under Class Q. The Secretary of State or the Crown in doing that would need to recognise that the right only subsists for 12 months. But in principle, if that was not thought to be an insurmountable problem, there is no reason why it could not be done in that way.
Mr. Brown, I'm struggling to get future into B or C. Can you help me?
Well, I could see that it may be harder in relation to B or C. One could try and I take your leadership's point.
So if you're looking at a future, the most comfortable fit on your argument would be that you're looking at A, preventing an emergency.
Yes.
But just on its plain language, the predicate would seem to me under B or C that you've got an emergency or you've had an emergency.
Yes.
That would be a more comfortable fit.
I wonder though about mitigating.
Well, that was, I think that was when, yes, if I hesitated at all, that would be over that word.
Which might have a preventative aspect to it, I don't know.
You can certainly mitigate things in advance. Well, in ordinary planning speak, one can, I don't know. But, so, yeah, I understand entirely your ladyship's point. Yes, yeah. For my purposes, it's enough that you could, that the future possibility is embraced by A. I would probably keep a finger in B, but recognising that in the main, that will be for a present or past emergency. If one comes then to the conditions over the page, again, the court has seen these. Notice to a local authority as soon as practicable after commencing. I'll come back to that when I deal with my learned friend's case. And then condition B, which is that on the expiry of 12 months, the use has to cease and the land has to be restored unless permission for the development's been granted by virtue of granted by virtue of any provision of the schedule or an application under Part 3 of the Act. And so the court will see that Class Q expressly contemplates the possibility that what began as an immediate short-term fix under Class Q might subsequently become a permanent or long-term solution if permission can be obtained in the way suggested. Just on that point, my lord, I don't believe anything turns on it. But I did note in taking your lordship to this, Mr. Beglan drew attention to the fact that the application, that the routes for obtaining permission will be a provision of this schedule, in other words, part of the General Permitted Development Order, or an application under Part 3 of the Act. And I accept that if one looked simply at those words, that would suggest there needed to be an application for planning permission to a local planning authority. And so, for example, your lordship's ladyship saw section 293A this morning, which is the power to make an application to the Secretary of State in the case of urgent development. 293A is not in Part 3 of the Town and Country Planning Act, and so wouldn't qualify in that regard. The one caveat, which, as I say, may not go anywhere, but I think, depending on where my learned friend wants to go with this, it might do. The court should be aware of the fact that in a case called Huff or How, H-O-U-G-H, the Secretary of State was the court was dealing with a situation where an initial development had been commenced under Class Q, and that was converted into a permanent permission by a special development order, which is again done under Section 58 of the Town and Country Planning Act. It's like a GP, like a general development order, but it's specific to particular types of development. And the court in that, one of the grounds for challenge was that overrode the wording of condition Q1B, and the court said, well, why can't it do that? It's a piece of delegated legislation. You can impliedly repeal or amend an earlier piece of delegated legislation, and indeed there is a provision of the GPDO itself, it's Article 1.2, which says that the GPDO applies to all land except where you've got a special development order which effectively overrides it. So I simply put down the marker that there is the potential, although I accept it's not what condition 1B says, the courts have so far held that you can also move to a permanent permission via a special development order. I don't believe anything turns on it, but it was a point raised by my learned friend, and I make that response simply so the court's clear of our position.
And as a matter of fact, no application or urgent application has been made under Section 293A in this case?
No application under 293A, nor has there yet been a formal approach to, in relation to an SDO. Those are matters which are actively being considered, and your lordship will appreciate that in order to, well, at the moment, if the Secretary of State does wish to maintain either Wethersfield or Scampton or indeed any other facility beyond the 12-month period, something is going to need to be done in order to regularise the position because 12 months will expire. But those are conversations that are happening amongst those behind me at the moment. But at present, there's no formal application. Your lordship's absolutely right.
And do you have any experience of the timeline for a 293A application?
Well, look, I personally don't. Those behind me, I see shakes. I could take instructions on it because it having been done in How, there must be that experience. But I don't know off the top of my head what the answer to that is. It's, as an SDO, it would be significantly quicker than obtaining planning permission, even by 293. Well, it could be, because it depends upon the goodwill of another government department. But with that goodwill, it may well be quicker. So, my lord, if one looks simply at Class Q to start with, there's no dispute that this is development by the Crown or that it's on Crown land. The sole question is whether there is an emergency. And in that sense, or that regard, the court's seen the definition of emergency in Class Q, paragraph 2 at page 34. The three broad headings: an event or situation which threatens serious damage to human welfare, the environment of the place, security of the United Kingdom, and then specific meanings given to damage to human welfare and damage to the environment. Look, can I make 2 points about just the overall structure given the conversation that's taken place this morning? First, my Lord Justice Lindblom asked Mr. Beglan whether development that was within Class Q would necessarily fall within Section 293A, and Mr. Beglan said he thought that it would. My Lord, in many cases, in my submission, there will be a clear overlap between the two, and you could go under either route. But 293A is only available in cases of national importance.
Yeah.
Those words don't appear in Class Q. There has to be serious damage, and one might have a query as to whether or not a damage in one village or one small location is sufficient for that purpose. But in my submission, one could envisage a situation in which there was serious damage without it necessarily being a matter of national importance to deal with it.
Yes, it's a question of which subsumes the other, isn't it?
Well, indeed, whether the two don't need necessarily to be, one doesn't have to subsume the other wholly.
No, I mean, there was no significance to my question except to really to seek to understand the scope of the concept of emergency.
Yes.
Which doesn't have to be a national.
No, one can have an emergency which is at a local level, and in my submission, provided that would result in, or that would threaten serious damage in one of the identified ways, then Class Q would be available, even if it was not of national importance. So, my Lord, that's the first of the 2 points. My Lord, the second relates to the observations my learned friend made about Mr. Justice Waksman describing this definition as exhaustive, and the extent to which it's relevant or appropriate to bring in other dictionary definitions. Can I simply ask the court to note at the moment that within Q2 subparagraph 1, an emergency is an event or situation which threatens serious damage to, and they're one of those three things. And Lord, in my submission, it's quite clear that unless it falls within those three things, it's not an emergency for the purposes of Class Q. And there may be other circumstances which, in common language, one might describe as an emergency. But if it doesn't risk serious damage to human welfare, the environment, or security of the United Kingdom, for the purposes of this provision, it's not. And similarly, when one comes to what is meant by serious, or what is meant by damage to human welfare or damage to the environment, the court will note that both paragraphs 2 and paragraph 3 tell us that events or situations only amount to damage to those concepts, only if they involve, and then there is a closed list of things which are applied. And in that sense, in my respectful submission, Mr. Justice Waksman was entirely right to describe this as exhaustive. You either come within the list of onlys, or you don't, even though that may mean that it omits a number of things which in common parlance would be described as an emergency. So, look, with that definition there, if one starts, it's the Home Secretary's clear position, Mr. Justice Waksman agreed, that there is an emergency. The Secretary of State would say there has been, there remains, and there is likely to be an emergency within Class Q. The background to that, the court will have seen both from Mr. Banner's witness statement, which is in the supplementary bundle at page 88, but I don't ask the court to turn it up unless you particularly want to, but also in the emergency statement, which is the document that formed part of the submission to the Minister on the 28th of March, when the decision to use Class Q in relation to Wethersfield and Scampton was taken. I'm happy to go into the detail of those if the court wants me to, but if the court's happy with just a summary, the points that we've set out in our skeleton argument, paragraphs 6 to 13, first of all, at the end of December last year, there were over 105,000 asylum seekers in the UK who were in receipt of accommodation and cash support. Second, that is the highest ever level on record. It represents an increase of over 25,000 from the previous year and of over 45,000 since December 2020. Third, there are a number of factors which have caused or brought about that increase. In terms of the main four, the headline points, the availability of accommodation depends upon turnover, and during the pandemic it was simply not possible to process the same number of applications. Secondly, as a result of the pandemic, the Secretary of State suspended the cessation of support. In other words, once a decision has been made that somebody can claim asylum, is entitled to remain in this country, at that stage, accommodation for them would ordinarily cease. The expectation they would go out, find a job, and look after themselves. That was suspended during the pandemic for understandable reasons. Thirdly, there was numerically a significant increase in the number of people arriving in the UK in small boats in that period. In 2022, there were over 45,000 arriving in small boats, compared with only 28,000 the previous year. And one of the points made both in the the emergency statement and Mr. Banner's statement is that although other areas of asylum seekers arriving may have gone down, proportionately people who arrive by boat, there is a greater chance that they will be destitute and therefore in need of accommodation. And then in addition to that, there are other issues such as the Afghan resettlement programme, which on its own has added some 8,000 people to the number of accommodated individuals in this country. So that those are, if you like, four of the key reasons why numbers have continued to increase. And even before October, November last year, those factors had necessitated the widespread use of block-booked hotels in order to provide accommodation. However, the situation reached what Mr. Banner describes as a particular crisis point last year, when the facility at Manston, and that's a facility that's designed to accommodate 1,600 people, and where it was only ever intended that they would pass through over a period of 24 hours, where Manston became dangerously overcrowded. There were just under 4,000 people living there, and they were there for considerably longer than 24 hours. Now, that, as the court may recall, gave rise to real concerns about their health, their welfare, the standards of accommodation that were there. It's an immediate crisis that was resolved by decanting people into what were then called spot-booked hotels. Spot booking didn't mean that it was just one room here, one room there. Quite often it was entire hotels that were taken over. But the point about spot booking is that it was only on a nightly or a two-nightly basis, whereas previously hotels had been booked for entire months in advance. And underlying that was the intention that that would only ever be a short-term response, pending the provision of more suitable long-term alternatives. In any event, at the end of March this year, the Home Office was accommodating over 48,000 individuals in about 380 hotels. The cost of that of the order of £6.2 million a day. Critically, the number of asylum seekers shows no sign of abating. By the end of March, the total number being provided for had risen to 109,000. And although nobody has a crystal ball, the Home Office at the moment, their estimates are predicting that there could be as many as, I'm not saying there will be this number, but there could be as many as a further 56,000 people arriving this year, and that could lead to the supported population increasing from the current 109,000 to somewhere between 120 and 140,000 people. So those are the basic facts that are set out in the emergency statement and in Mr. Banner's witness statement. If one puts those into the definition of emergency that one sees in Q2, we are, at the Secretary of State's submission, in a situation in which an unprecedented number of people are seeking asylum in the UK. Many of those people are destitute. That's not surprising, given the circumstances in which they arrive here and the circumstances that they've left in their home countries. But by definition, they are likely to be vulnerable. There is consequently a pressing need for accommodation which the Secretary of State is under a duty to provide, and which, if she fails in that duty, is likely to result in those people becoming homeless. And if they do become homeless, then leaving aside the fact that it places the Home Secretary in breach of her statutory duty, there would be a consequent risk of illness or injury or even a risk to life. That general situation was and remains, we say, a continuing emergency, the effects of which would be reduced, controlled, or mitigated by the use of sites such as Wethersfield. We go further than that. The situation at Manston last year was you can either call it the height of the emergency or a particular emergency or crisis in its own right. It was resolved, as I've indicated, through the use of short-term accommodation, spot-booked hotels, but that is not, and it never was, a sustainable long-term solution. And providing accommodation to which those people can be decanted would be taking action in connection with that particular crisis. And finally, if steps are not taken to provide additional accommodation now, then given the anticipated increase in the number of people arriving in this country over this year, there is a serious risk of a repetition of events at Manston, which would be a future emergency. And providing accommodation at Wethersfield, increasing the capacity, not just at Wethersfield but at other sites, will help prevent that future emergency. And so on that basis, we say if one applies the definition found in Class Q itself, Mr. Justice Waksman was, we say, with respect, obviously correct to conclude that there is an emergency for those purposes. Now, significantly, I've not detected anything in the submission of either the appellant or the interveners which say, if you go through the process that I've just done, look at the words in Q2, apply them to the facts, that the conclusion that has been reached and the conclusion that was reached by Mr. Justice Waksman was wrong. The contention that Mr. Justice Waksman was wrong is not based on applying the words in the specific statutory definition. It's based on importing words from outside of that. And in particular, in arguing that Mr. Justice Waksman was wrong, my learned friend has provided the court with dictionary definitions of an emergency. In his witness statements, Ms. Goodings has done some research on Google and provided some other definitions as well. And on that basis, and by reference to the principles set out in Benyon, that even where you have a specific definition, it can take colour from the ordinary meaning of words used, the potency of the phrase. He says the concept of emergency carries with it notions that there has to be something unforeseen or unexpected, something sudden that arrives unexpectedly and is then short-lived. Well, I make my position clear. I don't take issue with the general proposition that Mr. Beglan derives from either Benyon or cases such as PACCAR, however one pronounces it. But, in my respectful submission, that can only be taken so far. And in particular, I haven't seen anything in either the quote from Benyon or the case law that my learned friend cites, which indicates that in applying the general principle that words can be coloured by their natural meaning, even where you have an extended definition, I haven't seen anything which indicates that you can do that to the extent that you override the clear and unambiguous language of a specific definition. And that, in my submission, is what would be required if you take my learned friend's approach in the present case. And so, for example, I've already indicated to the court, I don't think Mr. Beglan takes issue, you can use Class Q to prevent an emergency. And I say it's self-evident that you can't deliberately take steps to prevent something which is completely unforeseen or unexpected. I recognise Mr. Beglan says it has to be expected imminently, but nonetheless, there is an element of foresight there. More importantly, and this is the particular point made by Mr. Justice Waksman at paragraph 71 and paragraph 72 of the judgment, here we have a specific definition which isn't limited simply to an event, a word which might lend itself to the claimant's, the appellant's submission. Class Q2 specifically talks about an emergency as an event or a situation. And in my respectful submission, Mr. Justice Waksman was entirely right when, at paragraph 71, he said that contemplates something that may occur over a period of time and or be of a continuing nature. And that is one of the key reasons why the learned judge rejected my learned friend's argument that you have to import these wider concepts into paragraph Q2. And in my submission, he was obviously right in that regard, because if you do import them, you end up rendering the express words that one sees in the definition meaningless. And I respectfully say that you can't take the general principle or canon of construction to that extent. So I say, if one looks simply at the wording that's there, there's no foundation for the argument that class Q is not in principle available. If there is an argument that it can't be used, it depends upon words that are not in the definition, and I resist that as a matter of statutory construction. There are two further points that I would, however, add to that, and they are these, and it goes back to the submissions I made about the temporal ability to use class Q. The first is that even if the court agrees that an emergency could not be a state of affairs that continued for a number of months, that does not explain why the crisis at Manston last year was not an emergency. That was an unforeseen, short-lived incident. It was brought about by a number of things, a particular period of good weather in which the number of people arriving in small boats was extraordinary and unprecedented, by a terrorist incident at the Jetfoil facility as a result of asylum seekers who were living there had to be relocated as a matter of urgency, and a power outage at the facility at Harmondsworth, which also required people to be moved at extremely short notice. That was unforeseen, unpredicted. It falls squarely within, in my submission, everything that my learned friend says should be imported into the definition. There was an immediate response to it, spot booking of hotels, but it was a short-term fix, and we are now taking action in connection with that. There's no reason in my submission why that can't be done. So that's the first point, even if one buys in the idea that things have to be unforeseen or unexpected. The second is, and it goes back to the point that I've made about the Secretary of State's concern, which is set out very clearly in Mr. Banner's statement, that if we do not provide additional capacity quickly, there could well be a second Manston type incident, and that would qualify as an emergency, and that in those circumstances the present scheme would also qualify as action taken in order to prevent that happening. Either one of those two things on their own in my submission would be sufficient to bring the proposed development within class Q. And that is why in our skeleton argument we have said that the emergency to which this is a response is existing, past and a future. The action could be justified under any one of those three heads. I turn next to the submission made by Mr. Beglan and the interveners, which is that one should take a restrictive approach to class Q because it overrides what they describe as the normal process of consultation, and because it removes decision-making powers from democratically elected decision-making bodies. And the suggestion that is made is that this is somehow unusual, that it's contrary to the objectives of the planning regime, and therefore of itself a reason for construing class Q restrictively. Lord, I touched on this earlier, and in my submission it is misconceived. It is true that resort to class Q means that there's no need for public consultation. But that is the consequence of virtually all permitted development rights, and those have been with us from the beginning of the modern planning system. They are just as much a normal route for obtaining planning permission as any other. I recognise that some permitted development rights carry with them an obligation on the developer to seek prior approval of the local planning authority for certain particular aspects of a proposal. But many, if not most, permitted development rights do not do that. And even where a prior approval regime applies, the powers of a local planning authority are more limited, they're limited to particular topics, and the normal process of consultation is significantly modified. But in that regard, Mr. Beglan says it's noteworthy that class Q doesn't have a prior approval. I agree with that entirely. It's noteworthy that in a world where prior approval could have been imposed as a requirement, the GPDO does not do that. That was a deliberate decision and choice that was made in bringing Class Q forward. And I do say that one shouldn't use the absence of consultation or arguments about the normal structure of the planning system as a basis for reinserting something which the draftsman specifically, and in my submission, deliberately omitted in the case of Class Q. The next argument that's raised against me and from a point of view of construction is the comparison with the power under Section 293A to make an application direct to the Secretary of State in cases of national importance and where it's necessary to carry out the development as a matter of urgency. What Mr. Beglan says to the court, if I understand it correctly, is that Mr. Justice Waksman failed to recognise the distinction between urgency and emergency, and that there's some sort of hierarchy there where if 293A can only be used in urgent cases, then crikey, it's got to be really, really urgent before you can get into Class Q. In my submission, again, that's wrong. It confuses two separate things. In deciding that there was an emergency, Mr. Justice Waksman simply applied the definition which is set out for that purpose in Class Q. As he pointed out, and it's paragraph 76 of his judgment, Section 293A is a different creature. I've already made the point that it requires national importance. Class Q doesn't necessarily do that. It's true, 293A will carry with it a degree of consultation. In order to go to the Secretary of State, if there are objections, there will then be a public inquiry. That of itself is likely to mean that however urgent 293A is, it's not going to be an immediate or quick fix, because holding public inquiries takes a degree of time.
Did you say paragraph 76 of the judgment?
My lord, I said 76. Let me just.
No, I just wanted to check the reference with you.
Yes, 76.
Right.
Okay. No, fine. I didn't write it down.
Thank you.
Thank you. Yes.
And in that regard, my lord, I do say that the different triggers are deliberate. One is urgency, one is an emergency. Critically, and this is where, if one is looking for again to highlight the differences, although Section 293A is more complex, it's a route that will get you ultimately through to a permanent permission, and one might understand why in those circumstances a degree of consultation, a degree of inquiry is required. Class Q is more procedurally straightforward, but it gets you only to permission for 12 months. And that in itself may be one of the reasons why, in drafting it, the draftsman felt it was appropriate not to require things such as prior approval. Yes, it avoids the need to go out and ask what a local planning authority thinks, but it's only going to be there for 12 months, and at the end of that you have to put the world back the way that it was, unless you've managed to obtain planning permission by another route in the meantime. And so, in my submission, Mr. Justice Waksman was entirely right. There is no ranking between 293A and Class Q. There are situations in which one will be usable and the other will not. There will be areas of overlap between the two. But where there is overlap, the decision maker is entitled to take advantage of that choice.
Did you say you had a choice in this case? Could you have gone 293A?
Well,
I mean, you meet the. I would have.
293A, I can tell Your Lordship, was considered, but given the timescales involved in it, and bearing in mind the concerns, we were in good weather now. I mean, I appreciate at the moment Wethersfield's still not up and running, but steps are being taken to make it ready to receive people as soon as possible. And it comes out very clearly from Mr. Banner's statement. There is a concern that although we don't know when the numbers will go up, they will go up, and this is the kind of weather where that happens. And so, against the timescales of 293A, Class Q, knowing that it was only for 12 months, and knowing that at the end of that period, the Secretary of State will have to do something to convert that into a permanent permission if she still wants to carry on using Wethersfield, which, and I make no bones about it, that is part of the plan at the moment, is to carry on using Wethersfield. But for that reason, we will have to make some other kind of application or obtain an SDO or whatever else it may be. But Class Q allows that. That's the condition bit that says you can.
I really just wanted to follow through. I think the threshold conditions for 293A, you would say did apply. The development in question was of national importance. I mean, the issue.
The Secretary of State, I'm sure, would say this is a matter of national importance.
And there is an urgency. I think what you say is there's more than an urgency.
Yes.
It's an emergency,
Yes.
but there is at very least an urgency.
Yes. But that doesn't. The fact that we could have gone down that road,
Yeah.
in my submission, doesn't preclude.
Well,
As I say, it's not a.
They're
There's
not
no
mutually
ranking.
exclusive.
It's not a ranking at all.
The question I was going to ask you, which I think in a way connects to the last question of my ladies, was this. Urgency and emergency are different concepts. As to the difference, an emergency perhaps connotes something that is and has to be dealt with swiftly. Of course, it's urgent to do it, but it's also something that has to be done decisively, quickly. And perhaps that lies behind the concept of the 12-month limit. Whereas urgency is something that can be conceivably more chronic, if you can put it like that. It could last longer. It's urgent and it continues to be urgent for quite a long time. So there's a kind of hierarchy of acuteness, if you like, in this. Is that a fair way of looking at this language?
And if I hesitate, it's over the hierarchy of acuteness, because
it's not a very elegant.
They're different things. Urgency is about time, and emergency isn't necessarily about time.
Yeah.
There may be elements of time that factor into an emergency, but it's not. They're not. Then it is an apples and pears comparison. My respectful submission.
Yes, but perhaps one needs to reflect on how best to put this. I think, but the submission you're making is that an emergency is something very acute, as well as very serious in its implications, whether they, in whatever.
Look, I say an emergency is what Class Q2 says it is.
Yes.
And if you have those risks of serious damage to one or other of the categories, then and it falls within it, then that is an emergency. Now, it goes back to, and this is, it's part of my learned friends case is, well, all these people are in hotels, they're not in danger of becoming homeless. The Secretary of State is fulfilling her duty, therefore you can't use Class Q. And I say that's a simple misconstruction. You can use Class Q to take action in connection with an emergency. You don't have to be in the middle of the height of the emergency to do that. And if what you're doing is taking something, whether it's putting people in tents or putting them in hotels, that was a short-term fix that was always suboptimal, then there is no reason why. Now, in doing that, you will need to be aware of the fact that you're only going to get permission for 12 months, and that might be a reason why ultimately you choose not to go down that road, but it's not a reason why you can't choose to go down that road. And there's nothing that says you can only use Class Q in circumstances where you wouldn't make an application for permission. Indeed, the condition specifically recognises that you can. Once you've instituted Class Q rights, you can make an application for permission. You can convert it into a permanent use at the end of the day. And so the fact that ultimately you might want a permanent facility doesn't have a bearing on whether there is an emergency which allows you to go under Class Q in the first place. Because that must be right, because otherwise the condition would be meaningless.
But there'd be nothing actually to stop the Secretary of State making those applications at the same time as he or she continues to rely on Class Q.
Necessarily, if the permission is going to be in place at the end of the 12 months, then yes, and at the moment we're looking at needing to make an application fairly quickly, or to whether it's to ask the Department of Levelling Up Housing Communities to make an SDO, whatever it is, those things will need to be put in place before the 12 months expires, because we will need to have the new permission before the end of that period. And so those are steps that will take place in parallel with actual use under Class Q. And they will have to, because it's the only way that we could get a permission which would allow us to go seamlessly from Class Q to permanent use.
But none have been made yet.
Not yet, my lord, no. They are. I can tell your lordship they are in contemplation, but they have not been made yet.
lest it be thought that that implies the absence of an emergency as such. You say clearly not.
Well, look, a large part of it.
I'm not putting that proposition to you. I'm simply completing, if you like, the logic that you seem to you seem to urge on us.
There are. First of all, there's a lot of work that's going into making these sites ready for Class Q, the work at Wethersfield has already started. There is nobody in occupation at Wethersfield yet. But it isn't something where you just flick a switch and you suddenly bus people in. There is work that needs to be done to make sure, if nothing else, that the facilities are fit for the asylum seekers who are going to live there. And so that needs to be done. And that is work that it takes time. It's being done at the moment. And that is where a large part of the drive of the effort at the moment is going. But those who sit behind me are acutely aware of the fact that the clock is ticking and that they will need to do something fairly shortly about that. There will be, your lordships hadn't been troubled with it in this case, but one of the other aspects of Class Q is it doesn't apply to things that are EIA development, that require an environmental statement. And in circumstances where the use is only for a year, the conclusion that it's not likely to have significant effects is relatively straightforward. It doesn't necessarily follow that you would get the same conclusion if you're looking at a permanent use. And so there will be, it's not simply a matter of saying this is what we put on site at the moment, can we just have permission to keep it there? There will be considerable additional work, and your lordship, I know, will be very familiar with what goes into even a screening direction for a longer use, a decision whether or not an environmental statement is required. That is the sort of thing that cannot be done overnight. It is being done, it's being worked on in the background, but if there isn't an application yet, it's because we need to get our ducks lined up first of all.
So, right, thank you.
Thank you. My lord, the next point that's raised is that it's the condition in Class Q which requires the Crown to give notice as soon as practicable after the commencement of development. And Mr. Beglan argues that that demonstrates that Class Q was intended to be used only, he says, in cases where it was impossible to give advance notice. And in this regard, I respectfully adopt the reasoning of Mr. Justice Waksman. It's paragraphs 73 to 74 of his judgment. Lord, I readily accept that Class Q is intended to be available, amongst other things, in cases where prior notice is not possible. And I'm willing to accept that that may well be one of the reasons why the condition is phrased in the way that it is. There would be no point requiring the impossible. But it's not, in my submission, a basis for concluding that's the only circumstance in which Class Q could be relied upon. And certainly if that were the case, one would expect that to be spelt out more clearly. There's one provision relating to notice. It kicks in at a point in time which would be workable, achievable for Class Q, no matter the circumstance in which Class Q is invoked, whether it is the sort of thing where you couldn't have given notice earlier or where you could have done. That is the point at which it's been sought. My Lord, next, it's argued that Mr. Justice Waksman gave insufficient weight to the temporal factors. It's said the appellant says they're unclear when Respondent first considered the emergency arose, and that's a similar point that you see set out in the submissions of the interveners as well. They refer in particular to the fact that there hasn't been a sudden and significant increase, but a gradual increase over the years. Well, my submissions on that are essentially the ones that I've made about the approach to the interpretation of Class Q. There is no temporal limitation in Class Q. There is no reason why emergencies, situations cannot last over a long period of time. World wars take many years to be fought. It would be surprising if somebody concluded that there wasn't an emergency throughout the entirety of that period. I don't suggest we are in that territory here, but it makes the point that an emergency can be a prolonged state of affairs, particularly in circumstances where the legislation talks not only about an event but also about a situation. And at various stages, the interveners, the appellant, have sought to, if you like, re-describe events. It's been put as not as an emergency, but as a nationwide lack of provision or simply pressure on resources. Well, one might be able to describe it in a number of different ways, but with my respectful submission, that's of precious little help. One has to come back to the definition. It fits within the definition. It's an emergency. The fact that you might also call it something else doesn't alter that fact. Lord, in terms of the reasons advanced by Mr. Beglan, I think there's really just one other substantive point. It said that the judge gave insufficient weight to the question whether development was actually needed in order to prevent or mitigate the emergency. And your Lordship will recall one of the last points Mr. Beglan made is, well, if the Secretary of State does her duty, then there is no requirement for this. In my submission, that again it's a non sequitur. It confuses the obligation of the Secretary of State to fulfil her statutory duty with the toolbox that is available to her in order to meet that statutory duty. And one would certainly hope the Secretary of State will never be in breach, but it may well be that she needs to resort to Class Q in order to ensure that that is the case. And if that is the situation, if it falls within the definition of an emergency, there is no reason why she cannot use Class Q. And so, for example, we have in this case not just the fact that there are people in hotels at the moment, and the Secretary of State has made no secret of the fact that ideally she would like to decant some of those people from those hotels into other accommodation. But there is also lying alongside that the fact that if the current predictions about more asylum seekers arriving are correct, then it may be that the whole of a new facility such as Wethersfield is taken up simply with that new increase. And the fact that people will then remain in hotels, which is not what the Secretary of State wants, does not mean that this ceases to be an emergency. In essence, my learned friend's argument amounts to this: you cannot use Class Q if there is some other way that you could solve the problem. And that simply cannot be right. There will be many situations in which the Secretary of State has a menu of possible solutions and chooses what is considered to be the best of them, or one of the better ones, and goes down that road. And if that fits within Class Q, then there's no reason why it can't be used, simply because you could address the problem the other way. And indeed, if that were not the case, then there will nearly always be another way of addressing a problem, and it would be extremely difficult to see how Class Q might ever be used. Lord, can I just check my notes in terms of other points?
Yes, of course.
Yes. Well, Lord, I've picking up on your Lordship's question to me about the Respondent's notice, and I touched on this just before the short adjournment. Having listened to the way in which Mr. Beglan has put his case today, I haven't detected anything in it which suggests, or where he has urged on the court that there is an area of judgment where there should be deference to the local authority. As I have heard it, his argument has been, understandably, very much along the same lines that we both approached the argument in front of Mr. Justice Waksman, which is that the facts are essentially agreed. There are questions about what do you use when interpreting Class Q. Those are points of law. Those are properly for the judge. They were for Mr. Justice Waksman. They are properly for this court. My Lord, in those circumstances, and in an area where it's not being suggested that there should be some deference to the council's view, I don't think it's necessary for the court to decide whether that is right or whether, or indeed to consider the other side of the coin. I would simply put the marker down that as I did just for the short adjournment, that if one looks at the situations in which Class Q can be relied upon, and the definition of an emergency, including matters such as the security of the United Kingdom, and I appreciate we're not in that third tier, but there are areas there where there is real difficulty in saying that there should be deference to the local authority. If there is deference, then I would stand by what we said in the Respondent's notice, but for the present purposes, my Lord, I'm more than content for the court to approach this on the same basis as Mr. Justice Waksman did, which is within the confines of this particular case. There is no dispute about facts. It's a matter of law, and the court is able to determine that without needing to defer one way or the other.
Right. So the sum of that is actually that you're not asking us to determine the issue in the respondent's notice.
Well, I don't believe it's necessary for the court to do that, and it may well be an argument that is better had in a situation where there is a factual scenario where that is necessary. Right. I'm conscious that the court entirely, understandably, is wary of making decisions in a factual vacuum.
Yes.
This is not a case where it's necessary to go down that route.
Right.
But I do put the marker down that there may be occasions where we do need to come back and say, actually, there should be deference, not to the local authority, but to the Secretary of State, for the kind of reasons that I've outlined. Well, Lord, I think that really brings me to one last point, which is not so much a response to Mr. Beglan, but to the interveners. And there is some suggestion in the interveners' written submissions that the court should go behind Mr. Justice Waxman's conclusion that the reasons why the Secretary of State is doing this are not just about cost. And in particular, the interveners have referred the court to the statement which was made by the Minister, Mr. Jenrick, in Parliament on the 29th of March. Lord, I'd say the following about that. First, there's a clear finding of fact by Mr. Justice Waksman. That is something this court would not normally interfere with unless effectively Mr. Justice Waksman had taken leave of his senses. There was no basis for that conclusion, and it's not actually suggested by any of the interveners that this case falls within that range. And so on that basis alone, I would ask the court not to go down that road. Second, my lord, in my submission, the argument that is advanced is misconceived, in that this is a decision that was made internally by the Secretary of State. Of course, the world needed to be told, but it's not a situation like a planning inquiry where there's a duty to give reasons in a decision letter. The decision itself was taken on the 28th of March. If one seeks the reasons for that decision, then on a normal public law approach to it, one would look to the submission that was made to the Secretary of State, which included the the emergency statement, which sets out all the matters that I've taken the court to. Cost is clearly one of those factors, but it is not the only one. And if one seeks reasons, that is where one should find them. It is wrong as a matter of principle, in my submission, to regard Mr. Jenrick's statement to the House as the decision letter or the reasons for the decision. I don't say it doesn't contain some of the reasons. There are certainly, I'd be making it very clear, I don't accept that there is any inconsistency between Mr. Jenrick's statement and what is set out in the emergency statement. I do say, it's not surprising, the emergency statement has a little more detail behind it than Mr. Jenrick's statement in Parliament did. But the argument itself should fail for the interveners for that reason. They're looking at the wrong place for the reasons that are there. My lord, if the court's with me on either of those, then I don't need to get into the interesting argument and the exchange of views between counsel for the Speaker and the interveners about whether this would amount to a breach of Article 9. If your lordship is with me on the submissions that I've made, then I readily acknowledge that neither the interveners nor I are seeking to impeach or question anything that was done in Parliament. The difficulty that would arise, and this is the point that the Speaker makes, is that if your lordship were to go down the road of assuming that Mr. Jenrick's statement is the full, complete and definitive statement of the reasons, and were to also to go against me on the submission that there is no inconsistency, I may well find myself in a situation where I would be driven to say what Mr. Jenrick said in Parliament is not the full reasons. And I would be the person who was then impeaching what was said. And that is the point that's covered by the Speaker's note. It's covered by the Heathrow Hub case. And the point that's being made there is that Article 9, you can't apply Article 9 simply by looking at what the party seeking to rely on the statement does. If it puts the other side in an impossible position where they cannot defend the claim without themselves falling foul of Article 9, then there is an Article 9 objection to that material being used. My Lord, I stress, I don't for one moment consider it necessary for the court to go down that road.
No.
It's possible to deal with it in the way that I have done, and if your lordships are with me on that, then Article 9 simply doesn't arise. But it having been canvassed in the way that it did, I thought it important for the court to know where I stand.
Yeah.
Could your lordship just give me one moment?
Of course, yeah.
My lord, Mr. Grant reminds me there is one thing that I forgot to deal with, and that's the point going back to Class Q about the references to emergency being in a place. And I mean, here I have nothing respectfully to add to what is said by Mr. Justice Waksman. I'm just trying to find my reference to where in his decision, in the judgment, he dealt with it. But in essence, he concludes in a place means somewhere in the United Kingdom. I mean, the question that I was asked at the time is, where would this happen? To which my response was, well, I can't say exactly where people would be made homeless. It would depend where they were, when they'd arrived, whether they'd been turfed out of the hotel they were staying in. But wherever it is, they will be in a place in the United Kingdom. And that is all that is required for the purposes of Class Q.
Paragraph 77.
I'm very grateful. You're one step ahead of me. Unless I can assist the court any further, those are my submissions.
No, thank you very much, Mr. Brown. Thank you. Yes, Mr. Beckman.
Well, thank you. And in relation to the use of the word somewhere, the learned judge picked that up just after 77, paragraph 78 as well. Well, just some short points by way of reply, if I may, taking the learned friend's submissions in much the order they were delivered in. Firstly, in relation to the use of the phrase requirements and prohibitions within section 296A, the Act is clear and specific about where requirements which are required to be adhered to at pain of various further steps are set out. And equally, it is clear in relation to prohibitions. Just to give some examples in relation to where the word prohibition is specifically used, it's used, my Lord will be well familiar with stop notices. Section 183, subsection 6, stop notice can be used to prohibit certain activity. It features in relation to tree protection orders in sections 202C and 202D. It features in relation to the recovery of expenses for removal of prohibited adverts in section 223. So those are just some examples. There are, of course, more. In relation to positive requirements, and that's why these two words are found together in the same phrase, requirements or prohibition, the requirements being the positive, the prohibition being the negative side of that particular coin. In relation to requirements, of course, we have enforcement notices themselves in section 172. We have requirements that can be imposed more generally for the maintenance of land, that's section 215. And one of the things that the court will see, looking over the general scheme of the Town and Country Planning Act, is that, for example, section 172 is within part 7, it is within the enforcement part of the Act. Section 215 is not, it's within the special controls section of the Act, slightly later on. And so that is why the references in section 296A are to references to things that occur by the Act, because it's not limited to consideration of Part 7. Another example in relation to requirements, section 204, dealing with requirements for regulation of trees. So there are some examples. Secondly, insofar as the learned judge said that doing something without planning permission was essentially prohibited, we do say he was wrong in that respect. We have the obligation in section 57, but in terms of the way the Act uses the word prohibited, it is directed in a different way. as my learned friend was looking through the Act and taking the court to the provisions dealing with certificates of lawful use, of course, it's perhaps just interesting to note in terms of the consistency of language that enforcement action is the choice of phrase within section 191, where one's testing whether or not development has become lawful. The test is it possible to take enforcement action as earlier defined against that development now? So those are some points on specific phrases within the Act. Next, in terms of the way that section 296A is designed to work and the breadth of the language that is used, and its common ground between us that it is a broad use of language, both in subsections 4 and subsection 5. It is that breadth which means that it is more important and more legitimate to give greater weight to the purpose of the provisions. And I go back to my earlier submission about what the overarching statutory purpose of these provisions is likely to be. And in my submission it must be to provide an effective means of enforcement to all of those bodies to which the Act now applies. And again, in terms of the point about why strike the balance where the respondent says the balance is struck and stop injunctions being brought forward, stop declarations being brought forward, stop ultimately the Secretary of State being subject to interim injunctions in judicial review proceedings, which happen to involve matters that are covered by section 296. Why is the balance struck there? In my submission, there is no good answer to that point, and the better answer by far, in terms of the reasonableness of the provision, is as we suggested earlier, that in fact, given the additional protections that it apply in the case of an injunction was not intended to be excluded by section 296A, and that's why the language isn't there. One might expect if there was to be effectively ouster of jurisdiction of this court, in a case where otherwise the Crown is now subject to enforcement process, that would have been expressly mentioned. The next point Mr. Brown makes is to say, well, the appellant's position doesn't make sense because they accept that in a case where an injunction was made, committal proceedings would not be appropriate, or in fact in a case where an enforcement notice had already been served, injunction proceedings couldn't follow on from that. But the answer to that is the answer that I gave earlier, that if one's dealing with the Crown and the officers of the Crown, where the expectation is they will comply with the law, there is no need for those further steps in relation to any of those potential avenues of relief, and that is entirely consistent with the general immunity that is in section 296A1 in relation to criminal liability. That's where that Act starts, and everything else that follows it is consistent with that and of a piece with it. Moving on to the second limb of the debate and the definition of the word emergency. As we were discussing earlier, each of the three limbs of Class Q still requires an emergency. That's the foundation of the operation of any of the limbs. And what that goes to demonstrate is the importance of placing proper weight on the presence of the word itself. And to paraphrase what's set out in Benyon, emergency is a potent phrase. It is designed to connote a very specific state of facts, as I indicated earlier. And there is nothing in my learned friend's submissions that shows that the idea of an event being sudden or unexpected, or any of those typical incidents that describe an emergency, were intended to be removed where that word is used within Class Q. So it's not a case that it doesn't say an emergency which is sudden or unexpected. It doesn't need to, because those qualities are inherent in the word itself. Next, in terms of the breadth of the application of Class Q, which on my learned friend's case allows development without restriction as to scale, so it encompasses scale of the kind that we're discussing here, provision for the housing of up to 1,700 people. Against that kind of backdrop, the Secretary of State's case is that this provision is capable of applying to a possible future emergency. And our submission is that that is much too broad. Whether one just uses the natural language of the words or whether one looks to the purpose of what those provisions are there to do. And in that respect, I would simply respectfully echo what my Lord Justice Lindblom said about the difference in quality. Is we do say there is a difference in quality between a situation that is urgent and one that constitutes an emergency. And if one's dealing with a provision that allows essentially unlimited scales of development, it is all the more important that the word emergency is properly restricted in its scope. So Class Q could say, for example, development which is urgently required. It could, whilst maintaining broadly the language that is used within section 293A, provide for further circumstances where, for a short period of time, things could be done under permitted development rights. But it doesn't use that language. It uses noticeably, markedly different language within the same overall statutory scheme. And the absence of any ability to control by prior approval matters of scale, matters of design, matters of access, any of those issues which typically raise significant planning issues. That again is not something which we say favours the Secretary of State's case. It rather indicates the importance of confining, in appropriate terms, the use of the word emergency. And against all of that, it is important to bear in mind the chronology that is before the court in terms of the decision-making process here. This has been an issue since March 2020. Napier Barracks was being the subject of decisions and ultimately use under Class Q by about September 2020. And then we have seen the decision-making process that more specifically relates to these three sites from November 2022 and moving onwards. All of that, no one of these factors necessarily says definitively emergency or not, but all of them are relevant, and we suggest that all of them really tend very strongly against the final suggestion that this is an emergency. In relation to guarding against a future emergency, the court has my submissions earlier, where the word preventing is used. It's used in the context of an emergency, something that is expected imminently to happen and that has those qualities. Where the word mitigation is used, of course, mitigation can mean different things depending on context, but where it appears within Class Q, my submission is what it's intended to address are the harms that would otherwise be arising as a result of the emergency, and it's not a further freestanding ability to look to things that have not yet happened. In relation to the solutions that have been shown to be available, I took the court earlier to the various ways in which the emergency statement deals with that. In his submissions, Mr. Brown says that the hotel accommodation was always suboptimal accommodation, and plainly that's right. There may well be an urgent need to address these issues. One wouldn't cavil with that. Neither of those things answer the question of emergency. In fact, both of them tend in the opposite direction. There will often be situations of seriously suboptimal accommodation faced not just by asylum seekers, but by very many others. And so in terms of the toolbox and whether or not there is an emergency justifying the use of the accommodation here, it is right to return back to the case that the Secretary of State is not saying, even now, that there is some imminent risk of a breach of statutory duty. And that is important because that is an essence of the case that's put forward in the emergency statement as justifying emergency provision. But it is not there on a closer analysis of the facts. All of what has been said in relation to the definition of emergency is consistent with the approach that was taken in the primary legislation in the Civil Contingencies Act. And at the end, I would invite the Court's attention back to the explanatory notes that set out the nature and the gravity of events, the specificity and the need to deal swiftly with events of the kind that are identified within those explanatory notes. Well, Mayor, of course, Temporal. Thank you very much. Those are my submissions.
Do you want to come around? Thank you. Well, thank you both very much for very clear submissions, concisely presented to the court. We are very grateful, not only for your oral submissions, but also, we should say, for your written submissions and the skeleton arguments. We're grateful too, I may say, to counsel for the interveners who have assisted the court within a very short time scale by their submissions too. Submitted to us in writing. We, of course, are conscious of the urgency of these proceedings and the timescale envisaged for next steps. We shall therefore endeavour to produce our judgment in as short a time as we can. We're not going to do that straight away. We need to reflect on the submissions made to us. Once we have done that and prepared our draft judgment, the draft judgment will be circulated in the normal way to parties for typographical corrections and minor textual or factual corrections only, an agreed draft order, and any submissions relating to that, and hand down in the normal way in due course, whereupon attendance by counsel or indeed anyone else will not be necessary. That is the arrangement we put in place. I would like to stress here and now, though it will be made clear yet again when the draft judgment is circulated, that it will be subject to the embargo provisions. Legal representatives have a responsibility to ensure that those embargo provisions are properly understood and applied. Otherwise, consequences may follow. Thank you all very much.